Today we got the Attorneys for Freedom and the Armed Scholar in the studio to talk about guns and freedom. You're not going to want to miss this conversation. Stay tuned. This is attorneys Andy Marcantel and Marc Victor, the Attorneys for Freedom law firm, and we got a great guest in the studio today, Anthony Miranda. You guys know him better as the Armed Scholar. How you doing today, gentlemen?
I'm doing great.
Awesome, man.
Yeah. First of all, I think we should explain, where are we right now? Is this place slightly different, Mark?
It looks a little different, right?
Only to the very keen
Yes.
eye, though, because our studio, this is not our usual studio. Our usual studio is under construction. And I'm excited to say we are building a really, really awesome studio right now.
Yeah, this is really going to be, I don't know what we're going to call it, but this studio is going to reflect a real commitment to excellence here.
You're right. We need a crazy cool name.
I'm impressed by even what the team has set up, making this. I mean, I wouldn't know the difference. I'm sure the viewers maybe the background's a little bit different, but your guys' team did an amazing job in setting this up.
Dude, you know, you're finding out about our team.
Oh,
man.
your guys' team.
I hadn't seen this before we walked in today to film this, and I felt like I was in the Twilight Zone. I was like, oh my gosh, it's uncanny. Yeah, great job, guys. But this is our temporary studio while the big studio is being built right now. Our brother Anthony Miranda here has been hanging out with us in the law firm for the last couple of days.
Yep, it's been fun. Like Mark said, getting to meet the team, spend time with you guys, see what you guys do. I'm thoroughly impressed by both of you guys and the rest of your team members, from the marketing side to the training division to all the attorneys, paralegals, everybody that works for you guys. I mean, your guys' team, I can't speak highly enough of what you guys are doing.
I always say it's easy to talk. People can say anything they want. We're the greatest. We do this. We do that. People talk a lot of trash, but actually walking the talk is a completely different thing. I mean, that takes some effort. You really got to spend some time. And, it's one thing to kind of see people on videos and this. It's another thing to sit down in the offices and talk about the law, talk about what's going on, how we do cases, to learn about the strike force, to see what's going on, to meet the customer service team. We get more 5-star reviews from our customer service team than I ever imagined we would get, because people know, and I tell everybody who works here, you might get called into the office, told you're doing a good job, and we can't use you any longer because good isn't going to cut it at our place. We're not interested in good. We're not interested in having the second best law firm. We're truly, truly committed to excellence. Doesn't mean we do everything perfectly. We make mistakes. When we do, we own them. We fix it. We take responsibility. We learn from it. But a real commitment to excellence, why do it if you're not going to be committed to excellence? I also think that reflects what you do with the Armed Scholar. As I told you, I watch your channel. It's a place that I go because I know I'm going to get a very good legal analysis from a lawyer who's reading a case. I'm a lawyer. If you're going to tell me about a case, I want a lawyer who's read the case, who understands the area of law, who's going to do a way better job than I could ever do summarizing the case for people who aren't lawyers. It's just really amazing job you do over there at Armed Scholar.
Yeah, I was going to say, you're a good communicator of the law, and most people don't have a law degree. They don't understand all the legalese, and you're really good at taking these really complicated concepts, condensing them down in an easy to digest, easy to understand format. We think it's great.
I appreciate that. There's a lot of time that goes into some of these things. People don't see the research that goes behind reading all the briefs, all the procedural stuff that happens with this, some of the cases or federal regulations that are proposed and all of that stuff, state bills that are changing. There's a lot of time on the front end that leads to the 8 to 10 minute condensed version. But that was the goal all along with the channel, is take these complex legal topics revolving around the Second Amendment, condense them down the best that I could, so that the average person that comes to YouTube and wants to learn about these topics can understand what's going on.
Yeah, you do a great job there. I've really enjoyed, and I do this all the time because I just can't help myself, right? Because we talk about guns, we talk about the Second Amendment, we talk about self-defense, and all that stuff's great. I mean, that's all we do at our law firm, so we talk a lot about self-defense. But, when the cameras are off, and I got you sitting in my house, right? We're having dinner. And I'm going to ask you, because we're freedom guys. And I'm going to be like, dude, I hear you talk about guns and Second Amendment, but, how do you feel about this? How do you feel about that? Because I'm interested in, is somebody really for freedom? I mean, everybody says they're for freedom, but to me, freedom is not just the right to do things you like to do. Freedom is the right to do whatever somebody wants to do with their own body, property, money, and time. And so long as they leave everybody else alone, like, do what you want. And especially when people are doing things that I don't think they should do. I might find it immoral, unhealthy, unwise, unwarranted. I might say, this is going to screw up your life. But I will defend your legal right to do it and to get a feel of what your thoughts are in that area, which is what we've done over the last few days. It's been really heartwarming for me to know that Anthony's not just a gun guy. And again, I don't say it to minimize him. There's a lot of issues here.
There's a lot more to everybody than just guns.
Yes, but it's good to know because, a lot of people are one issue people, right? You see this on each issues, right? Some people are just legalize weed. Oh, let's talk about the other drugs. Let's talk about guns. Let's talk about all these various issues. How do you feel about that stuff? And lots of times what I uncover is we're not dealing with a freedom person. We're dealing with an activist who's got a hobby that they want to advocate for, and they don't give a crap about anyone else's rights to do things that they don't do. Like, that's not an American position to me. So it's been really good for me because, we have these content creators who we pay, and I want to know our money's going to people who are hardcore freedom guys. And I feel even better about supporting your channel after knowing really what's in your heart on the question of freedom. I mean, what are your thoughts on it, Andy?
Well, I've had a chance to talk to you and sit down with you in our offices. You've even gotten to sit in on a few of our strategies and talking on cases and everything like that.
And for the audience, I did get to sit on some of the conversations, and I can tell you guys, when they say they put the team to help you guys in these critical situations, they throw everything at these. I mean, you are the highest priority when something like this happens to you guys. So I can vouch for that because I've seen it now firsthand.
Well, I've been very impressed by you, and even more, like Marc said, even more just happy that we have a relationship professionally, and happy that we're sponsoring such an awesome channel and an awesome resource.
I appreciate it, guys. Appreciate it.
So for today's conversation, we didn't really plan anything, which is how we like to do it, And so our attitude was to just bring you in here and say, Anthony, what's on your mind? What do you want to talk about, brother?
Yeah, I mean, obviously top of mind, because what I do with the Second Amendment is firearms related things that are going on at the state level, federal level, regulations and all that stuff. And I know we just had a conversation with Sheriff Bianca before this, and the audience will see that. Top of mind right now, obviously, is we talked a lot about CCW permitting, and there is obviously coming from a state like California, where we have some of the most restrictive gun laws in the nation. Usually they're used as the exemplar for other states to follow. And we've seen the trickle-down effect from other states following what California does with CCWs or rifle bans, magazine bans, all that stuff. So CCWs is close to my heart. I'm a plaintiff in one of the main lawsuits challenging California's SB2 law, which is the new CCW restrictions that were passed in direct response to the Supreme Court's decision in Bruen. And I get to see firsthand the frustration of gun owners in the state of California, not only from the laws that we have to live under, but specifically CCW permitting systems. Luckily for me, I'm in a pretty permissive county where it's fairly red, and the sheriff, like Sheriff Bianco, are really good at getting people CCW permits.
Is he your sheriff?
No, he is not my sheriff, no. But there are really good sheriffs like Sheriff Bianco in other areas in California where even prior to Bruen, you didn't have to do this crazy may issue discretionary justification for why you needed a concealed carry permit. In my county, they allowed even just self-defense. Now, that was not the case for all counties in California, which is pretty insane, where you would have to have some crazy justification for why you wanted to defend yourself and your family from criminal conduct.
So I want to talk about SB2.
Yeah.
SB2, obviously, for people who think, okay, well, it's a California law, it's California specific, and it doesn't affect me in my state. That's just crazy, People's Republic of California nonsense. It's not something I need to worry about here. That is not the case, and we should talk about that. But I want to back it up a little bit and talk about the history of SB2. I remember when it was being passed, there was some tumultuous back and forth to the Court of Appeals and remands and everything like that. Can you bring people up to speed on what the history is?
Yeah, so background of SB2. So we have to kind of really go way back. Originally, the Bruen lawsuit resulted out of a New York challenge to New York's May issue permitting regime. And within that, they had super restrictive permitting process as well as the whole May issuing permits, where you would have to meet certain good moral character or good cause standards to be issued your permit in the state of New York.
Yeah.
It was effectively impossible.
Yeah,
Effectively impossible.
Yeah, because you're an American and because you want a firearm to defend your family, just wasn't a good enough reason.
Not good enough reason.
In fact, there really wasn't a good enough reason.
There was, I mean, we saw examples of people who, like, their reasoning was, well, in my neighborhood, there have been 15 murders reported within a 2-mile radius in the last month. And so I walk home, I'm a woman and I walk home at night. And so that's my sorry, not enough. Not enough.
This particular constitutional right, you got to satisfy someone in the government that you need this right. Like, are you kidding me?
Yeah, the issuing permitting agency, whether it was your city, PD or your county sheriff, whoever, you would have to meet whatever vague, subjective requirement that they had decided to set.
Imagine if the First Amendment was treated like that, right? You only get to, like, why do you need to say this? Why do you need to, say things about the president or whatever? You have to convince somebody you need a permit to exercise your right. It just seemed pretty outrageous to me.
Yeah. So that New York challenge went all the way up to the Supreme Court. Bruen was the decision, which was a result of that. And the Supreme Court struck down May issue licensing regimes, also did a lot in the Second Amendment landscape as far as reshaping some of the analysis that happens with the Second Amendment, looking at text, history, and tradition rather than tier-based scrutiny. But when you're talking about the CCW context specifically, what happened as a direct result of Bruen is literally 8 days after Bruen was issued, the state of New York passed what is known as the Concealed Carry Improvement Act, which,
the ironically titled,
the CCIA, the Concealed Carry Improvement Act. And so out of that, within New York's new law, they not only made the process to get your permit harder and more expensive with the fees and all of that, but then they also added in a bunch of caveats to where even if you got your permit, you went through all these harder steps, the more fees, all of that, and you had your permit. Now they included a bunch of express sensitive locations where you could not carry lawfully, even though you were a CCW holder. Things like zoos, parks, museums, schools. And then the big one was the catch-all phrase, the catch-all clauses within these laws, which people coin now the vampire rule, which essentially means that you cannot go into any business, any private location, or anywhere that's open to the public without getting the express permission of the business owner, either by them telling you or posting a sign that says, yes, we permit concealed carry at our location.
In other words, the default setting is guns are not allowed at any business unless the business owner specifically tells you guns are allowed. I mean, who the hell are they to make these kinds of judgments on private property, impose them on private businesses? Just unbelievable. So, I mean, un-American is really the word that comes to mind here.
And the note with this, too, is even within the Bruen decision, you had statements from Justice Thomas where he's expressly said, because there was some discussion during the oral arguments where New York had argued that potentially the entire island of Manhattan could be classified as a sensitive location because of how populous it was, how many people were there, the claimed public interest and risk that are expressed there with so many people, and it was good enough that we have law enforcement in these areas to defend you. And even Justice Thomas and Bruen said that you can't make the entire island of Manhattan a sensitive location, and the purpose of that was to prevent these types of laws that passed as a result of Bruen, but they still passed. Now, the reason why I'm mentioning the Concealed Carry Improvement Act is because that was passed 8 days after, and then California tried their hand at almost an identical law soon thereafter.
Other states did too. Hawaii passed something
New York,
very similar.
New Jersey.
I think Maryland might have put something through. So the typical, anti-gun states, right? The very states that wanted to have the discretion. We had to go to beg a government official to exercise your constitutional right. The May issue states.
And to be fair, we saw this coming from a mile away. I remember when the Bruen decision came out, Mark, you and I did a video, and we talked about that little thread of language that the court left hanging out there. Now, we've traditionally, not allowed firearms in these sensitive places.
They invited this
We're
controversy.
the left is going to pull on that string.
And that is always the problem with dicta in some of these opinions. And we've seen that thread get pulled a lot more in other cases where you had Kavanaugh in his concurrence where he mentioned that shall issuing permits is potentially permissible. Now, that's been skewed where, You've had some federal agencies and some states argue that that is him saying that if some sort of permitting scheme operates as shall issue default, well, then that permits that type of scheme. And they've actually used that CCW shall issue rationale dicta by Kavanaugh to now justify the NFA as well in a recent decision out of the Fifth Circuit. So that's why I'm saying that type of language is always very concerning when you see it in there. But yeah, to go back to California, California originally tried their hand first at that CCW permitting process similar to New York. Didn't pass originally because they tried to do it through a special session. But of course, the next year they came back with SB2 and it passed. And it's nearly identical to what New York does, where we have the same sensitive location restrictions, same enhanced permitting process system. There have been some counties in response who have moved more to shall issue, and they're issuing fast, and they're, more people are getting access to it. They don't have to have this crazy good cause or good moral character determination, rationale when they apply. Self-defense is good enough. But then we've also seen some counties within California, like LA County, be very delayed in issuing permits to the point where they're still not necessarily issuing permits, and they've even caught litigation against them and mentions from Pam Bondi and the DOJ saying, you are expressly violating what the Supreme Court said in Bruen. You need to get moving on issuing some permits, or else we are also going to jump in this lawsuit. So it's been a little bit of a mess in California, like it always is in response to any of these big decisions. The Ninth Circuit has not been helpful to us at all, as they never are. Anytime we get a pro 2A decision at a district court level and it gets elevated to the Ninth Circuit, sometimes we get a win from the 3-judge panel, but almost immediately if we get a win from a 3-judge panel in the Ninth Circuit, it goes en banc and they reverse it lickety-split.
Because I remember I had some hope when SB2 originally passed. Yes. Basically, I was in charge. Marketing would come to me and say, hey, Andy, there's been a new decision or a new injunction or, a remand or a reversal or, there were certain times when it was paused. There was an injunctive relief where it was going up the chain. And so marketing would come to me and say, make a minute long short, about the newest development. So I actually had maybe misguided hope there for a minute that one of the judges along the way would do the right thing.
Yeah, and so for some context, I'm also one of the plaintiffs on one of the main lawsuits against SB2, which is championed by CRPA, which is a great organization within the state of California that does a lot for the 2A cause. Our case, we won at the district court level. It went up to the higher court, unfortunately, because it was also reviewed in conjunction with another California lawsuit and then also the state of Hawaii's Wolford case. Yep. The Ninth Circuit reviewed those cases, and it was this very interesting hodgepodge decision where on some aspects of SB2, they said potentially it's unconstitutional under Bruen. Some of the catch-all phrases, potentially impermissible. We're going to remand it back down to the district court to review some of those things. But when it came to a lot of the sensitive location aspects, specifically things like any location that serves alcohol, you cannot conceal carry. We're not talking about just bars. We're talking about minute marks.
Restaurants.
Any restaurant, minute marks that sell lottery tickets, you can't conceal carry there.
Crazy.
So there are, and then also parking lots in locations directly associated with, so you can't even if you want to go to a minute mart, where you probably want to conceal carry.
These happen to all be places where robberies take place happen. And dangerous
So
people.
I want to have my concealed carry permit on me when I'm stopping to get some gas at a minute mart. Well, I can't do that, and I'd be violating SB2, and I can't even have it in my vehicle in this parking lot of this minute mart. So what, I'm supposed to leave it at home?
Yeah. Unsecured in your car or something it's just craziness. It's just when you need it. Now, sorry, hold on a second. I got to go back out to my car or something. But, there's so much to talk about here. And let me say something that I think's going to sound really controversial for a second, but it doesn't bother me when we get a good decision out of the district court, as you mentioned, and then it gets up to the Ninth Circuit. And either the 3-judge panel does the right thing and then gets reversed by an en banc panel, or they do the wrong thing. That doesn't bother me. And I'll tell you why it doesn't bother me. Because we need decisions out of the United States Supreme Court. We need them to take the case up and say, you know what? What happened down below at the Ninth Circuit was a big mistake, and we want to clarify this, because that fixes it not just in the Ninth Circuit, but across the country. And I still, notwithstanding some decisions that left me perplexed and some refusals to take cases like on the AR-15 ban, notwithstanding all that, I'm still very optimistic about this particular United States Supreme Court. In fact, I think it's uncontroversial to say this is by far the most pro-Second Amendment United States Supreme Court that we have had in the history of our nation. If we're going to get a good decision, it needs to be now because the makeup of that court can change.
Yes.
We got some old time, Thomas being
and
one.
Alito. Yeah.
Thomas and Alito. You got two very solid Second Amendment justices on that United States Supreme Court. Either of them could die any day. Yeah. Right now, you get a Republican. But in a few years from now, because we know that pendulum swings, they could both die, and presumably you could get two more Dems, two more anti-Second Amendment guys. So we got bad decisions coming out of the circuits right now if the Supreme Court takes action. Because, this is one of the limitations of the United States Supreme Court. They only get to rule on cases that are in front of them. Mm-hmm. And so, some of the organizations that you've worked for in the past, that you're associated with, and us as well, because we're doing these kinds of cases now, dropping lawsuits in the circuit courts on the hopes that the United States Supreme Court will take this stuff up and do something with it. Like, now is the time. Yep. And so, I don't get discouraged when the Ninth Circuit or one of these other circuits does some horrible anti-second. I know people get upset, but okay, this is an invitation to take it to the U.S. Supremes.
Bruen only happened because a poor decision was made in the lower court.
That's right. And I think that's very important. So now is the time to get these decisions vigorously, work on them, litigate them. That's why we're dropping lawsuits all over the nation in federal courts. As you know, we're going after the Commerce Clause. Mm-hmm. And I think it's unfortunate that people don't have really any understanding of, like, we were talking about this, and I just sort of pulled a number. I don't know if it's exactly correct, but I think I said, man, if we got our way on reinterpreting the Commerce Clause, or just do the history and tradition thing with the Commerce Clause like you just did in Bruen with the Second Amendment, and 85% of everything the federal government, the NFA is toast, probably the ATF is toast. So many of those three-letter agencies just fall if you could get a correct interpretation of the Commerce Clause in Article 1, Section 8. And this is the one big thing I think people just don't know anything about.
And I think you guys are doing a good job. And I think through the association, you guys are going to be more active on that commerce. I know recently, I believe in the Morgan 10th Circuit case, which deals with machine guns, you guys filed an amicus brief
on the Commerce Clause,
which is, for people who don't understand, an amicus brief, that's essentially a friend of the court brief where an outside interested party can jump in and file something on behalf of one of the parties, and also just give judges more information on how they should think about certain issues. And so you guys do a great job with the association trying to do those things. I know you guys are ramping that up as well.
We are.
One thing I want to go back to that you mentioned is kind of the frustration with the Supreme Court. I know it's hard for a lot of people to see what's some of the cases, like the big, sexy, big name cases, like the Snope case you mentioned, which deals with AR-15s.
Yeah, that was disgraceful.
That was denied review, and it was still on a final merit. So that one was a little bit perplexing. And then out of that, you had a statement from Kavanaugh that said, "We understand this is an important issue. We understand that a lot of people are concerned about this. We believe that potentially this, is something that we need to address in a term or two.
And we're going to revisit." He says, "But why wait?"
Yeah. And they identified that they have an eye on a few cases that are developing. Now, which specific cases those are, we know that they have been looking at the Seventh Circuit lawsuits, which I would say that's what's frustrating is if you're waiting on the Seventh Circuit, why not take the Snope, I believe, Maryland case? Because it dealt with almost the similar issue where you had the same, rationale out of the circuit court dealing with, instead of using Bruen, they said, AR-15s are militaristic weapons. They're used, useful in military service, and therefore they can be restricted by a state. So that was definitely frustrating. But you still have statements from the Supreme Court, like Kavanaugh. I mean, Kavanaugh making that statement, it's interesting. You would, if you had Thomas making that statement. We know Thomas he wants these cases. He's expressed multiple times that lower courts and the Supreme Court are treating the Second Amendment like a second-class right. He has stated that.
He's right about that for sure.
Absolutely. Yeah. But yeah, there's frustration from some of the lower courts. But when it comes to the Ninth Circuit, we know how they're going to rule. They've been like this for years. The makeup of that court has been like this for years. Now it's shifting a little bit in the uniqueness with the Ninth Circuit en banc panel, since it's such a large area. It's a set number of judges, but it actually rotates. It's kind of like a straw poll every time it changes. So we just need kind of that one case that gets in there with a good makeup of judges to get the positive ruling we need out of the Ninth Circuit en banc panel. But, I'm hopeful. And when you look at, like you stated, the makeup of this Supreme Court, they are very pro-2A, and they've been fairly active when it comes to the Second Amendment in comparison to other courts. I mean, when you talk about Heller and Miller being, 17 years after they issued that decision, there was no real other Second Amendment case. I mean, in the recent history with this Supreme Court, you have Bruen, Rahimi. They took up Vanderstock. They took up the bump stock cases and the Cargill case. They issued that decision. Last term, they issued the PLCAA decision. And I think for the general audience, I know we focus so heavily on the big, sexy topics, the rifle bans, the magazine bans. Supreme Court states that's coming. Whether or not that's true, time will tell. But the Supreme Court thinks about Second Amendment cases or gun cases kind of in not a specific category. It's if they deal with like an ATF regulatory issue involving firearms, they kind of consider that, in my opinion, a Second Amendment case.
Right.
So, every term they're taking up one or two of these issues. The question is, what are those going to be this next term that's coming up here starting very, very soon? And there's plenty of cases. You have the Wolford Hawaii concealed carry case that's currently pending in front of them. The issue with that one, like other ones, is it's still on an emergency basis. So it's still on a preliminary injunction.
Right. These are the kinds of things we just don't know what's going on behind the scenes. Right? You could imagine Kavanaugh and Thomas pounding the table with Alito saying, we got to take this thing out of Maryland, right? We could for once and for all declare you don't get to ban AR-15s or any of those. There was a big list of weapons on that list, but you don't know. Maybe somebody like Barrett or Roberts said, look, I'm with you, but right now is not the time. Let the law develop in some of the others. So, I could imagine a conversation like that. Or worse, I'm not on board right now. And now if we take it, we're not going to get the decision we want.
I do have some, me personally, I do have some frustration. Now, obviously, this comes because I'm in California and I have to live every day under these things. But it is frustrating when you have the Supreme Court say, we need this to, percolate more in the lower courts. What more do you need to see out of, we know how various circuit courts are going to rule. When it comes to AR-15 bans, you're not necessarily going to have a huge circuit split because somewhere like the state of Texas is not going to pass a comprehensive ban on so-called assault weapons. So you're not going to get a decision on rifle bans from the Fifth Circuit. So you're not going to get this crazy circuit split. Instead, what you're going to get is you're going to have all the blue circuit courts like the Ninth Circuit, the Seventh Circuit, and second and third potentially ruling all one way, saying, yes, we can justify these rifle bans, magazine bans, or concealed carry restrictions. And then you're not going to really have the circuit split that you need because these other states aren't passing these things.
Right. Since we're talking about the United States Supreme Court, there are two things that irk me when people talk about the Supreme Court. The first thing that I hear is sort of a statement that says, the Supreme Court is just not being responsive to what the majority of people want in the United States. I don't have much hair left on my head, but what I got left, I want to pull out because they're not supposed to give a damn about what the majority wants. That is the reason they set it up the way they set it up. If you read the Federalist Papers, they discussed the Supreme Court is supposed to be the watchdog of the legislature. It's the legislature that is responsive to the will of the people. The Supreme Court, they're appointed for life. They're supposed to. Imagine if they were beholden to being reappointed.
Could you imagine if they shifted every 4 years?
Oh, my God.
Goodness.
I remember when the Dobbs decision came down and remanded the issue of abortion back to the states. I remember there was this huge public outcry saying, the Supreme Court's not reflecting the will of the people, as if that was an argument.
Right.
And yet we're sending it down to the states for the will of the people to determine how. I know.
But the will of the people argument is not an argument that is ever intended to apply to the United States Supreme Court. They're supposed to be immune to the will. Their job is to be the guardians of the Constitution and to strike things down. And by the way, when the Supreme Court invalidates laws that Congress has passed by saying they're unconstitutional, that is not an activist judge. That is a justice doing the right thing by invalidating bad, unconstitutional laws. Okay, that's the first thing. The second thing that irks me when people talk about the court, and this might be the most dangerous thing maybe said in recent years in the political realm, where this was the Democrats coming out, this was Joe Biden and Kamala Harris saying, we don't like that there's so many conservative justices on the Supreme Court. We want to pack the court. We want to put more justices who agree with us on the court. And every American should be absolutely outraged by that kind of statement. For starters, if I could go back to the Constitutional Convention and say one thing, cap the number of justices on the Supreme Court, because FDR pulled this same BS, right? Everybody knows about FDR's court packing scheme, which is said to have failed. It didn't fail. He didn't have to pack the court because the court changed how they did business, and that's a rat hole to go down right now. But that's a major problem that happened in 1937 as a result of the mere threat to pack the court. And so here we are again. Could you imagine if Joe Biden had put a handful of liberal justices on this? Donald Trump's going to come say, well, I'll raise you another 5. We'll have 200 justices on the Supreme Court before no time, and then we would have destroyed the third branch of government.
You have people who say now that the Supreme Court is a circus court. Could you imagine, like you said, if it was expanded every single year to an additional justice, one or two more?
We got to be, people on all sides of the issue should say, you know what? If anybody's talking about packing the court, we should shut that down in a second. It's hard to think of things that would more quickly destroy America than screw up the Supreme Court by packing the court.
Well, it's short-sighted. It's really short-sighted.
Right.
People, I think, get caught up in the current fever of politics and say, how can we score a win right now? These conservative justices keep getting wins for the other team. How do we get it? And this is a short-sighted approach, because when your current win jeopardizes your democracy long term, you're going to regret it, because that pendulum does swing the other way.
And it's even the same thing, like when you look at the cases themselves. I know everybody is so excited for certain issues to get to the Supreme Court, but like we've seen in some cases, sometimes it's not necessarily just the issue. It's the right facts. It's the right posture. It's the right plaintiff. It's the right procedure that the case has been built up through. And I mentioned the Hawaii Wolford case. That's still in an interlocutory posture. Yes, you had the DOJ jump in, Pam Bondi them say, yeah, Supreme Court, you should take this case. But the posture of the court has been, we don't take interlocutory cases. That's kind of in their track record of recent. They keep saying they want a final merits case, but that's on these organizations to decide how they want to push these cases up. But, it's not just the justices themselves. It's a lot of times you got to think beyond just the issue of this case. You got to have the right plaintiff, right facts, right posture, and right decision makeup down below that really then potentially pushes the federal government to seek cert. So usually what happens is the federal government seeking cert or the state seeking cert from the Supreme Court because they lost down below, more often than not, the Supreme Court grants review to those cases. But when we come to them losing, more often than not, they punt our cases and wait till a later time.
Another thing that struck me, and I'll poke at being a little controversial here because it's just what I do.
Controversial?
I know, it's just what I do, man. When Bruen came down, and they made clearly the right decision to say this whole May issue stuff, we got to get rid of that. And then they went on. You alluded to it very quickly. We went past it really fast. They kind of changed the landscape on how we decide Second Amendment cases. I said to Andy, that's the big news on this case. Yeah. I mean, I'm glad that they killed the May issue scheme. That needed to happen. But then they went on and did something tremendous, right? They brought up this sort of history, tradition stuff, which we were talking about the other day. Just because it happened a long time ago doesn't mean it was a pro-freedom kind of a rule. There are a lot of rules out there that you can sort of wipe the dust off the books. They weren't even talking about the Second Amendment. I mean, the Second Amendment didn't apply to the states. In some cases, didn't even exist at the time. Why are we looking to these older rules to say this is what the Second Amendment means? It doesn't. Look, I'm in favor of whatever gets us to more of a pro-freedom position. How we get there, I mean, I'm a little bit less concerned about. I mean, look, the Founding Fathers got there through a violent revolution against their own government. I am not suggesting that, but we shouldn't forget that.
Mark is not advocating for a violent revolution.
But we should remember they committed treason against their own. Our country was born by people who were radicals, many of whom were from Boston, like me. I'll note, Sons of Liberty.
Go Patriots.
Yes, go Patriots, go Sons of Liberty. Those were the radicals up in Boston. They weren't putting up with this 2% tax on tea that King George thought he was. I mean, these guys were radical, and had they lost the war, they would be swinging from a tree. There's no question they would be hanged. And so they didn't trust the government. That's why they had the Constitution. Look, you could have just set up a democracy and said, we vote on everything. But the reason you have a Constitution and call it a republic is because there's supposed to be a whole bunch of things that don't matter what the majority want, like free speech, for example. It doesn't matter how the majority feels about offensive speech. Like we protect, or at least we used to protect, offensive speech in the United States under the First Amendment.
Yeah, I mean, this was explicitly the reason for the Bill of Rights. It was to protect, in many cases, the tyranny of the majority against the minority.
Yeah. These people who argue within the will of the people, you're missing the point of why we're supposed to have a constitutional republic. I don't like it when people put together freedom and democracy, democracy and freedom, like they're the same thing. They are not the same thing. Democracy is majority rule. Freedom is self-rule. Those are different things and oftentimes not compatible.
Yeah, it's interesting. I mean, you've alluded to a lot there. I think, as I see it sometimes, the fact that people are calling for the Supreme Court to do the will of the people maybe shows that there's a breakdown more of those individuals that are supposed to be representing the will of the people, which is your representatives in Congress and the House and the Senate. But we've lost so much faith in them to actually do the will of the people that now we're looking to other branches like the executive through the president or various agencies, or now the judiciary to do the will of the people rather than do what their express job is under the Constitution and the Bill of Rights.
The will of the people only gets me so far. What if the people want socialism, right? A lot of people want socialism today. I mean, to stand up and say, look, we should have the will of the people. We should have a socialist country. Sorry, if you guys want to do socialism, you go over there and have fun and have a community pot where you pay community bills.
Go buy a piece of land in the middle of nowhere and set up your socialist.
Absolutely. You have every
Go find
right
a friend that's going to build stuff. The other one's going to do plumbing.
Which people can join voluntarily, but you can't rope in through force.
My only issue with socialism is the effort to drag people into it against their will. Like, I don't want to live in a socialist society, and I'm a free trade guy. If I want to spend my money on something at an agreed price, I want to be able to make that trade. I don't want to be told I can't make that trade. And if you have any sense at all, frankly, you recognize that it's capitalism that has raised standards of living. It's capitalism, and only capitalism, that is compatible with freedom. We should talk more about it in our country. I'm a proud capitalist. I'm a proud entrepreneur. I'm a proud American. Shouldn't be afraid to say those kinds of things today.
No, absolutely not.
Well, the conversation's traveled a bit, but to go back to it, and which is perfectly fine. My favorite conversations travel a bit. What's the status of your lawsuit right now?
Yeah, so right now, going back, the Ninth Circuit, after they issued their hodgepodge decision on SB2, they struck down some sensitive locations. So one of as a plaintiff in the lawsuit, one of my main complaints was that under SB2's current structure, I'm not allowed to carry at my place of worship, go to church and concealed carry. Under one of the express sensitive locations, I wasn't allowed to carry there anymore. So under the decision, they allowed the injunction to remain in place on some locations like churches and some other areas, but then remanded it back down to the district court for them to still look at some of the additional stuff in relation to how the Ninth Circuit ruled, which I don't agree with the ruling. So that's where it's currently at the district court, and it's moving along. There's been depositions and things like that, and I believe there's going to be an actual, which is interesting because the Cal DOJ did depositions in this case, which they really never do in any other 2A case that I'm aware of, or that CRPA and these other organizations have been aware of. So I think California's scrambling a little bit because they see the writing on the wall specifically with how this specific issue and this structure of law has played out in other jurisdictions like the Second Circuit and the Third Circuit, specifically like the Antonyuk case, the way that has developed in the courts, where you even still have the Second Circuit striking down pieces of New Jersey and New York's regulations that are very similar to SB2, saying that, no, you can't have this catch-all property ban. You can't just say you can't conceal carry anywhere unless someone tells you can conceal carry at these locations. So California, I think, is scrambling a little bit, and the litigation still going on at the lower court level. That organization specifically decided to just let it go through the lower court towards the final judgment in, like I mentioned, the Wolford, Hawaii lawsuit, which was in the same ruling. Yep. That one was different. When it came to the catch-all property ban in Wolford and out of Hawaii, the Ninth Circuit upheld the catch-all property ban, saying that since Hawaii, at least my understanding, since Hawaii allowed the business owner to either give you permission through expressly telling you or posting a sign, which was that kind of dual aspect, that it was permissible. And so the Hawaii plaintiffs sought en banc panel review from the Ninth Circuit. It was denied by the Ninth Circuit. You had a dissenting opinion from Van Dyke and some of the other judges on the en banc panel saying it's absolutely ridiculous. The way that this is structured right now pretty much only makes it so that you can carry on streets and sidewalks, even though you have a permit, which I actually disagree with, because even under the way some of these laws are structured, walking on certain streets or sidewalks in some of these express sensitive locations would still be a violation of how these are structured. So like I mentioned, Wolford's now in the Supreme Court. We're waiting to see. There's a conference coming up, but the California specific one is now moving in the lower court and going towards a final judgment.
Yeah, and to be clear on some of the just blatant craziness in these kinds of bills. I mean, like when you talked, for example, about the provisions that say the church is a sensitive area now. You can't take your firearm to the church, regardless of what the church says, right? And because, we represent many different church security teams who have joined AOR, right? Because we don't care about on duty, right? Some of our competitors say, well, if you're on duty, no coverage for you. We embrace, if you're on duty, we don't care, and it's not a problem. And so many of the churches are actually inviting armed security teams to provide security at the church. I mean, it wasn't a church, but we had the case out of
Portland, the Jewish preschool.
The Jewish preschool. I mean, he was on duty there protecting a Jewish preschool. And, to just wholesale, regardless of what the institution wants, to say, we've decided to take your right to make a decision. I mean, of course, nobody argues that if they wanted to say no guns at our church, they could definitely say that. But to say that you must have no guns at your church, even if you want guns at your church, you want to invite a security team in, you can't do that under the law.
And it's equally wrong for schools, and it's equally wrong for businesses.
Yeah.
It's equally wrong across the board. Yeah. It's outrageous.
Yeah, but I am optimistic. I don't want to be too pessimistic. I think at the end of the day, I think this Supreme Court is going to get it, if not completely right here, mostly right. I don't want to be too optimistic when it comes to the court, but you do have a very pro-Second Amendment. Look, we weren't even talking about the Second Amendment. When I was in law school, you had Miller, and nobody really knew what the hell Miller meant, right? I don't know what they were talking.
And it's interesting because you went to law school a lot earlier, and so I recently, when I was going through law school, I think in con law, our Second Amendment, case review was all of 10, 15 minutes of a class when in comparison to when you're covering First Amendment and all.
We didn't even talk about it in my law. There was nothing to talk about. No
we
decisions.
had Heller when I went to
We had
law
Heller
school.
and Miller. That was it. Yeah.
We spent about, maybe 5 minutes, 10 minutes.
Yeah.
Dude, I've been practicing for decades by the time Miller came out. So, but I'm just saying, I mean, this is something unique in American history right now to have these kinds of discussions about the Second Amendment at the United States Supreme Court. So we should take a step back and at least appreciate the time that we're in. I mean, look, until Heller, which I think was 2008 or something, it was still an open question about whether the Second Amendment even protected an individual's right to keep and bear arms. The argument in the Ninth Circuit was, no, this protects, the state's right to have a National Guard or some kind of collective right. I mean, that wasn't even settled as late as 2007 until Heller shows up in 2008. So we've gained a lot of ground in a fairly short period of time.
Yeah, and Bruen did a lot. I mean, we've alluded that it was specifically dealing with a lot of CCW stuff, but there was also language in there that took Heller a step further because after Heller, since there was no case decisions after that for like 17 years or whatever it was, you still had some lower courts and some states arguing that the Second Amendment does not extend beyond the curtilage of your home. So suddenly your rights vanish the second you step outside of your home.
Crazy.
So Bruen did a lot of work.
Yes.
A lot of people,
we actually are making a lot of headway in the Second Amendment space.
Absolutely.
But that is not the reason for complacency. We need to be greedy.
Yeah.
We need to be greedy with our freedoms.
Yeah, I agree. I
don't think the Founding Fathers, I think they would be absolutely shocked if they heard us talking about it. They would say, "Wait, didn't we make it clear in the Second Amendment? I mean, why are we even having these
Shall not be infringed. I thought that was pretty clear.
You and I were talking yesterday, Anthony, about all kinds of great organizations out there. You're very tuned in. As a constitutional law scholar, you are very tuned in to all the different great organizations out there. We got a few minutes left of the podcast, but I wanted to at least give a call to action to some different organizations that our viewers can go and check out and support with their money and their time and their effort. What would you suggest?
Yeah, so I usually do a two-pronged attack. For individuals, I think your state organizations are most important because that's what's going to impact you the most at a state level, especially if you live in a restrictive state like California. So CRPA is my go-to when it comes to California. Gun Owners of California, also amazing. They do a lot on the legislative side. Sam Paredes, who used to be the president of GOC, recently passed away. So Rob Young's taking over that, and they do a lot on the floor there in the legislature. in California. So CRPA is great. If you're in another state, look up your local, state chapters. New York State Rifle and Pistol Association. They're the ones out of New York that led to Bruen in that big decision. ANJRPC out of New Jersey. And then beyond that, if you're looking at national orgs, I highly recommend Second Amendment Foundation, Gun Owners of America.
How do you feel about NRA at this point?
So the NRA, I've been very vocal against the NRA for many, many years.
But there's supposedly it's a new day at the NRA.
They have changed structure. The NRA has been more active on some lawsuits and they've been active in some litigation. And they've definitely had a change of approach where they're not just collecting your money and doing nothing. At least they are now getting involved in a lot of these lawsuits. And I will say from the optics where you have the NRA joining in with these other organizations in lawsuits. So like you'll see lawsuits filed with SAF, FPC, FRAC, and then the NRA will join in these lawsuits now as well. So they are doing better. I think time will still tell if whether or not that will actually stick.
Yeah, we need to get over infighting is something that I do want to say. We had a podcast where we spoke to somebody who was on the board at GOA, and we asked him this question: what do you think about the NRA? He said, I think correctly, look, there's some things that we disagree about with the NRA, but what we're fighting for is too important to quabble over our small differences. We need to unite and fight for the Second Amendment, and we need to be allies rather than focus on small differences.
Yeah, and I would just echo what my good friend Sam Paredes, who recently passed away, who headed GOC, what he would always say is, don't fight over the little slices of the pie. The pie is a lot bigger than you think it is. And so he was all for pushing his organization to collaborate and work more with other organizations, including even within the own state. He worked a lot with CRPA and Michelle and Associates and a lot of those guys to move the cause in California. And I think a lot of these organizations originally had a lot of infighting. I think they're doing a lot better now in collaborating and pushing these lawsuits.
Anthony, guys like you, Jarrett over at Guns and Gadgets. Jarrett is awesome, and you guys do a great job at keeping the awareness out there.
Educating the public.
Yeah, excellent job. And I just got to say on behalf of me and Andy and everyone, like how honored we are.
Yeah, the honor's mine to work with you guys.
To have you talking about AOR and just telling people about AOR and doing it in a high character, classy kind of way, which just really... We feel very grateful and honored that you feel comfortable enough with our program, because I know for damn sure if you didn't feel we had a lot of conversations before you decided to talk about AOR, given your past experiences. But it's just been a great experience for us. We love working with you. We hope we continue to work together for the long term, and that's our intent. And it's been a great journey, man. I really appreciate you, brother.
And also, thank you so much.
And also seeing the activism of people like you made us want to put our money where our mouth is and stop sitting on the sidelines. We're a self-defense program. So we're in the trenches, criminal defense lawyers, not usually making the big picture arguments because we're fighting for individuals in the criminal justice system. Well, we got tired of sitting on the sidelines watching the battles. So we're putting our money where our mouth is with the Attorneys on Retainer Association. Our members probably know this, but it's something we're really proud of. We peel off a certain amount of every membership to put towards fighting for Second Amendment rights and freedom issues in general in those higher appellate courts, and we want to push things all the way up to the Supreme Court. So we're getting involved in the fight on that level too, man.
Yeah, that's what's amazing about you guys. You're always evolving. You're doing more. That was not something you guys originally had, but now with the association, you guys are getting more involved in these big picture Second Amendment issues, which is amazing.
We're bringing it big, man. And we're going to keep bringing it bigger and bigger all the time.
Yeah, thanks for being here, man. It's been awesome hanging out with you.
Thank you guys for having me.
Yeah. All right, everybody, go and check out attorneysonretainer.us to learn all about our self-defense program and what it can do for you and your family. Check out attorneysforfreedom.com to learn about our law firm and how we defend people in the criminal justice system. Until next time, this has been attorneys Andy Marcantel, Marc J. Victor, and Anthony Miranda signing out.
Peace.